Can I ask Professor Ishida now what you think are the most important or at least interesting features of Japanese ADR law and practice from a comparative perspective?
Okay, one of I think the most interesting thing about ADL in Japan is that even though we say like Japanese people prefer informal dispute resolution, and that is why we really litigate and rather we resolve disputes through ADL. But in 2004, the government enacted so-called ADL Promotion Act, but it's not that active even today. And so once we set formal dispute resolution, even ADR, people do not use that actively. I think it's very interesting. Both mixture of not only culture, but also kind of designed to do so. I mean, still many people hesitate to access the professional lawyers, and they feel like once it is set as formal ADR, then we need some professional to assist to use it. So, and people hesitate, first of all, people hesitate to access to professional lawyers, 弁護士. Plus, I have to say that even though the number of lawyers increased, still it is not that easy, I think, for ordinary people to access to 弁護士, especially in rural areas.
James, as a relative newcomer in Japan, but someone who's obviously worked and taught there for many years now, what's your perspective on this question? What do you find most interesting when you look at particularly mediation and other forms of ADR in Japan compared to your background in US and international law practice?
Well, I think that one interesting thing is that there seems to be a real appetite for international commercial mediation. The proof of that is that in 2018, a dedicated center was set up in Kyoto, the Kyoto International Mediation Center, really focusing on commercial disputes across borders. And what's interesting is that there may be a disconnect between the understanding of mediation within a domestic context in Japan and the way that mediation is promoted by the JIMC. So to be more concrete, perhaps many in Japan, when they think of mediation, think of really court-annexed conciliation. And that process is fundamentally different than the process offered by the JIMC. For example, the conciliation process can take some time. It's usually a series of short meetings. It's comparatively inflexible. So there's a standard procedure. Whereas by contrast, international standard mediation is known to be a process that, compared to arbitration, is fast and flexible. And the flexibility can actually lead to creative solutions. So it will be interesting to see how perhaps the perception domestically translates into any uptake or embrace of international commercial mediation. The JIMC has put together a panel of mediators from really all over the world. And many of the individuals have different styles of mediating. So I think that their approach is to be accommodating of both a more facilitative style, but also a more evaluative style. And there have been a number of mediator trainings now in Japan offered by outside institutions like CEDAR from London that in their presentation of the material, they really emphasize the facilitative approach. They also talk about ways of reality testing too, but they really emphasize the facilitative approach. So it seems like in terms of the training and in terms of the composition of the JIMC, they really want to accommodate both styles.
Professor Ishida, can I turn back to you and ask whether you can identify any particular major influences from abroad that are impacting on mediation law and practice or ADR systems generally in Japan? And also a flip side to that, whether you're aware of any Japanese government supported overseas development assistance type projects to try to help neighboring countries, particularly in the Asian region, to build up dispute resolution systems, and whether the Japanese style of designing and practicing ADR is influencing other countries in the region.
Okay, I can say that even though Japanese government really aware of overseas practice, and they really, as Professor Claxton mentioned, the Japanese government really want to internationalize Japanese mediation tribunal so that many big commercial cases are resolved not in Singapore or London, but within Japan. But the problem, I think, two problems. One is English, first of all. Not many practitioners, I mean lawyers, are good at speaking English, first of all, sorry to say. And they are not good at dealing with ADR matters in English. And second of all, even though there are many people, lawyers who have overseas experience, still their core of legal practice is trained by Judicial Institute of Legal Institute by Supreme Court, Shiho Kenshujo, and the training there is just based on how to write judgment and how to defend or the clients in legal proceedings, I mean, judicial proceedings, and not really focusing on ADR. So I have to say that even today, not many practitioners have the skill of ADR, especially kind of facilitating ADR. So in that sense, I think international influence is very limited. Their core is still kind of Japanese style of resolving disputes, and they have some experience. Most of them have experience in court conciliation, so they know evaluative ADR, but they are not familiar with kind of facilitating ADR. I think that's the reality. For court annexed mediation, we say shiho chote, but for facilitating mediation, even in Japanese, we call mediation to differentiate. And a group of bengoshi lawyers try to promote mediation, and they try to do that, like, providing training sessions. And I think the most important thing is that the proceedings itself, they try to do caucusing, I mean, having both parties together to facilitate negotiation. But in reality, many parties and representatives, I mean, bengoshi, hesitate to do that. And they are really familiar with court annexed shiho chote mediation. So, and there, they don't meet at the same time, and mediators meet separately, like plaintiff and defendant, like that, and they decide maybe this is a line for settlement. And still, I think many feel good at that proceedings, and many hesitate to have caucusing proceedings. So, yes, it's true that there are some group of lawyers who try to promote kind of facilitating mediation, but from a user's point of view, I mean, including lawyers who are representing clients, it's not that popular today. And as to international initiative, yes, even today, government are keen to internationalize ADR, and that is why JIMC is established in Kyoto.
Can I ask you, Professor Ishida, a different question, which is, what have been the biggest changes you think have happened over the last few decades in the field of mediation and ADR?
One of the big change after ADR Act was enacted is ADR Act was first of all established during justice system reform, 司法制度改革, and that stream was established, is made in line of deregulation, 規制改革, administrative deregulation. So one purpose of ADR Act is allow non-lawyers to deal with disputes. And after ADR Act was established, those people who were so-called quasi-lawyers, including 司法書士, judicial scriveners, 行政書士, administrative scriveners, or 税理士, tax accountants, they can allowed to handle disputes. If they are certificated, they get certification by the Ministry of Justice. Without that, it is punished by unauthorized practice of law under Article 72 of Attorneys Act. So now it's liberalized, and even quasi-lawyers can participate in this market. That is, I think, one big change. But as to practice, they are almost all domestic disputes handlers. So in that sense, still I can't see such a big impact of kind of internationalization.
James, can I ask you if you have anything to add to that, or whether you'd like to address another question that I'll also put soon to Professor Ishida, which is, what do you think will be the biggest transformations in Japanese ADR law and practice over the coming decades, or at least the next 10 years?
It's quite a horizon. I think maybe one thing to mention in terms of changes in the law is it is getting easier to be a foreign lawyer practicing in Japan. As of last August, the types of disputes that foreign registered lawyers can hear was increased, and it became a little easier to actually qualify as a foreign registered lawyer because you're now required to spend less time outside of Japan than previously. Also on the horizon, it will be possible for foreign registered lawyers to set up companies or corporations, law firms, with qualified lawyers in Japan. So maybe that's one legal change that impacts international dispute resolution. In terms of the big changes on the horizon, I mean, to my mind, one really interesting thing caused by the pandemic was the increased use of online mediation and online arbitration. And my thought is things will not go back to the way that they were before. There's long been pressure on attorneys to cut costs and to save time. This is a great way of doing that. And I think some people are thinking deeply about what is really necessary to have a fair arbitration or a fair mediation. And that's leading to some experimentation with different types of new processes. And I think clients like these changes. And so I think that will have an impact on the way that both arbitration and mediation are practiced.
Professor Ishida, you're nodding there, so do you have anything to add on this point?
Yeah, thanks for adding that. I think allowing so-called gaiben, foreign registered lawyers, to have to cooperate is one of the most important impact. And if I add more, maybe there are sudden increase of so-called in-house lawyers in Japan, even for middle size corporations, and they there are many corporations who have dealing with foreign corporations, and now they have, it's shame to say, but now they can make a kind of legal contracts finally, after having many in-house lawyers in the corporations. So, and they also have an agreement about tribunal, and they cannot say like all disputes should be resolved in Tokyo District Court. So that can be a good trigger to promote international ADR practice.
Have you noticed any other important or interesting developments caused by this pandemic?
First of all, the number of filings, sorry to say, the number of bankruptcy cases is increasing now. But as to ordinary disputes, I don't know. I mean, I have to say that my guess is that it's decreasing because you may be surprised or not, but anyway, even today, Japanese court doesn't allow e-filings, or, you have to physically file it. That's troublesome, especially under COVID-19 environment. But yes, it's true that because of COVID-19, the government's kind of promotion to government attitude to promote e-filings or e-proceedings is now accelerated. Yes, that's true. And also about ADR, now the government has a committee to discuss online dispute resolution, but still it's started to discuss.
James, I'll leave you with any last thoughts, if you have any, on this question of the impact on the pandemic.
I don't think I can add much to what Professor Ishida said, but I do think that mediation has a very important role to play, in particular online mediation, because of the pandemic, as firms and corporations are cash-strapped as they want to maintain their relations with their contractual counterparties. It seems that mediation should have a lot of appeal in those circumstances, and the fact that it can be done online should facilitate the participation of new parties who are maybe geographically far from one another, and it's much easier and much more flexible to set up the mediations. So I feel like that would be, to my mind, a very natural way forward. The question is, will people actually take that route? I'm not sure.
Well, thank you, both of you, for your time today, sharing your expertise, and wish you all the best for the next year, hopefully not quite as disruptive, and that lots of cases are resolved peacefully by direct negotiations or by mediation or ADR, and in the worst case by binding court decisions or arbitration. So thank you for your time today.